Professor Blackman is a prolific writer and scholar who has authored over 4 dozen law review articles and is the author of several books. He was also selected by Forbes magazine for the 30 Under 30 Law and Policy Award. On my right, Professor Dorff is our very own Cornell faculty member. He graduated from Harvard College and Harvard Law School. After law school, Professor Dorff served as a law clerk for Judge Stephen Reinhard of the United States Court of Appeals for the Ninth Circuit, and also for, after that, for Justice Anthony Kennedy of the Supreme Court of the United States. Professor Dorff is also a prolific writer. He's authored and co-authored over 100 scholarly articles and essays for law reviews, books, and peer-reviewed science and social science journals. He's also a co-contributor to Dorff on Law, a blog dedicated to law, politics, economics, and more. Please welcome the two speakers, and this should be a great event. Professor Blackman is going to take the stage first, and then we hope that we'll have a good engagement between the two professors. Thank you very much.
Thank you so much. Thank you. Thank you. This is my first time at Cornell. I've never been here before, but I am so happy to see Mike Dorff. We've corresponded for almost a decade now. We met in person 5 minutes ago, so it's great to be here. The topic today is Obamacare. And if you ever saw the movie Groundhog's Day, that's basically what this case is. We've all been here before. The facts are the same, just the politics are a little bit different. My goal here today is threefold. I want to talk about this new case in 3 regards: standing, merits, and severability. Okay? Those are my 3 goals. This story begins in 2010. Congress enacts the Affordable Care Act. This was a comprehensive law that fundamentally changed how health care is delivered in the United States. There were 2 major components I want to talk about. The first is what's called the Medicaid expansion. The Medicaid expansion basically told states we were going to increase the number of people who are covered by this government-funded insurance program. The other component dealt with people who were not on Medicaid. The other component was called the individual mandate. Okay, what was the individual mandate? The law said that you shall maintain insurance subject to a few exceptions that are not relevant here. Okay, why was this mandate enacted? To prevent people from free riding. The ACA ensured that people could be insured regardless of their pre-existing conditions. So they said if you're healthy or not healthy, get insurance now. That way you won't hamper the system down the road. Okay. Almost immediately after the ACA was enacted, it was challenged in court across the country. Conservative state attorneys general, private parties, and other groups argued that the mandate to buy insurance was unconstitutional. What was the argument? The argument was Congress does not have the commerce or necessary and proper powers to compel people to engage in a commercial transaction. Okay. The government argued to the contrary, that the ACA regulated an interstate marketplace. It was affecting interstate commerce. There was a broad regulatory scheme to which the mandate was necessary. They made all these arguments about necessary and proper. The government also made another argument on the taxing power. The government argued that the mandate was backed up by a tax, right? That is, if you go uninsured, you have to pay a tax. This is money given to the IRS in your tax return. It isn't labeled a tax in the statute, it's called a penalty. So the Supreme Court has this case, and they have to decide a few issues. The first issue is, does Congress's commerce and necessary and proper powers support the mandate? Okay, this is Part 3A of NFIB. Part 3A, the court says no, that Congress lacks the power to mandate that people buy insurance. The court says the most straightforward way of reading the ACA is imposing a mandate. You shall maintain insurance. Okay, Roberts reached that conclusion in Part 3A of the opinion. But then he pivots. We get to Part 3B and 3C of the controlling opinion. Part 3B discusses what are called saving constructions, the idea that when the court can read a statute in such a way to uphold it, the court has a duty to read it in that fashion. Then we get to Part 3C. And Chief Justice Roberts makes a few points. He says, look, Congress did not impose a tax. They didn't. This is not a tax. But in many regards, the ACA resembles a tax. It raises revenue. You submit this penalty with your tax return at the end of the year. The same tools the IRS has to collect taxes, they can use to collect this penalty. This walks and quacks like a tax, so maybe it is a tax. Okay. But I want to make very clear, the court did not hold the ACA was a tax, right? What Robert said is, we can read the ACA as giving people a choice. Buy insurance or pay a tax, right? That argument only works in 3C of the opinion because the penalty is raising revenue. Roberts did not hold the ACA was a choice. He didn't. I will die in this hill. In 3A, he said the most straightforward way of reading the law is as a mandate. Now, how do we know this, right? The plaintiffs in this case never challenged the penalty. They were very careful. If you look at the complaint and all the declarations, said we are challenging not the penalty but the mandate. Indeed, the basis for standing in 2012 was not the penalty. The basis for standing was the mandate. How do we know this? Because the penalty did not kick until 2014. There was no concrete injury from the penalty in 2012. The only basis for jurisdiction was the mandate, that the requirement to buy insurance was a legal command, regardless of whether there was a penalty behind it. Indeed, the plaintiff said, we will never pay the penalty because we're law-abiding. We want to follow the law. So the penalty played no role whatsoever in standing in 2012, and the penalty played no role whatsoever in the merits in 2012. There was some stuff about the Tax Anti-Injunction Act, which we can talk about later. That was sort of ancillary. But the core jurisdictional question, the core merits question was, is a command to buy insurance an injury? Yes. Is a command to buy insurance a violation of the Commerce Clause? Yes. And that brings us to the present day. In 2017, Congress passed a law, the Tax Cut and Jobs Act. This law did a lot of things. I don't know the first thing about tax law. I do nothing about Obamacare. The law reduced the penalty to $0. It was about $700 plus or minus. They reduced it to $0. Now you ask, Josh, why didn't they just repeal the penalty altogether? They strike out the penalty from the statute. Under the process they used, what's called budget reconciliation, they couldn't do that. They weren't allowed to. All they could do was certain financial changes, such as reducing the penalty. They did not touch a single sentence of the ACA, not a single word of it, other than the penalty being $695, dropping it down to 0. That's all they did. Now, many of you are probably watching the votes on the tax cut bill. I was. And as soon as Congress voted for this, they said, Obamacare is unconstitutional now. Like, I immediately recognized that the Roberts saving instruction can no longer hold. I was not the only one who saw this. I suspect at least some members of Congress recognized this, maybe Ted Cruz or Mike Lee or some of the other people, but I knew it. Shortly after the tax cut bill is passed, lawsuit is brought by Texas and eventually by a couple private plaintiffs. They argue that because the penalty was dropped to 0, the mandate is no longer constitutional, that the saving instruction cannot hold. Or put it in Roberts' opinions, Part 3B and 3C are gone. We're left with Part 3A. And in Part 3A, Roberts says the most straightforward of reading the law is a mandate, and that was the basis for jurisdiction. They also argue severability. They argue that because the mandate is unconstitutional, right, that other parts of the law have to fall. For example, the law's guaranteed issue provisions, which says you give insurance to everyone regardless of the health conditions, right? That's got to go. Texas goes further. They argue that the entire law has to fall. Okay. What does the Trump administration do? Initially, they say we'll defend most of the law, but the guaranteed issue and community rating have to go. Okay, this was the same position that the Obama DOJ took in 2012. A district court in northern Texas, which was picked very appropriately, ruled against the administration, or I guess, well, they ruled in favor of Texas. The administration was mostly on the same page. For full disclosure, the district court cited me like 5 or 6 times. See, I get cited by the opinions usually being reversed, but this is good. I'm actually cited by the majority opinion for once. The district court found that there was standing, that the mandate was no longer constitutional, and then severability, he said that the entire statute's got to go, that the mandate is essential to the law, the rest of the law cannot stand. The case was appealed to the Fifth Circuit. We had arguments in July. We'll probably get a decision, I would predict, in the next couple weeks, but what do I know? But I think we'll get one sometime soon. Okay, now I get to my actual argument in chief. I've already given you the main points. First, on standing, I think the court ought to resolve this. Right? In 2012, the only basis for Article 3 jurisdiction was the mandate. It was not the penalty. That's the exact same facts now. We have a mandate with no penalty. Indeed, Chief Justice Roberts asked during arguments, what happens if you have a mandate with $0 penalty? Kagan asked the same question. The exact issues we are debating now were discussed in 2012. Go back and read my first book on precedents. I talk about all these things. I didn't know these things would be relevant when I wrote this book in 2013, but they are, and it got cited by the district court. Jurisdiction cannot be waived. If there was jurisdiction in NFIB, there's jurisdiction here. It does not turn on whether there's a penalty. Second, on the mandate. The House argues, for example, that there is no mandate, that there's only a choice of paying a tax or getting insurance. Roberts rejected that in Part 3A of his opinion. He rejected it. Right? I don't have to be right or persuasive. I can say C3A of the opinion. Anything in 3B or 3C is now not relevant. Roberts only got to 3C because of the saving instruction, which cannot hold. Right? The law cannot be read as a tax anymore. Indeed, California's intervener basically acknowledged it. They told her, look, if you guys want to say that the mandate's unconstitutional, nothing else, fine. We don't really care. Just leave the rest of the law alone. The ballgame, though, is on severability. And this is where I think everything turns. Traditionally, severability works like this. We ask, what would Congress have intended? Right? What would Congress have wanted to happen if they were told that provision X of a law was declared unconstitutional? Right? This is the question of severability. Now, sometimes severability is sort of a mystical question, right? We just have no clue what Congress thought. But in this case, we knew what Congress thought in 2017. Is there an air raid going on? We getting bombed?
It's a test.
A test. Okay. Well, this is a new.
Test of your faith.
This is a new deplatforming where you just put air raid sirens while people are speaking. All right. So this is perhaps a case where we know what Congress thought in 2017. Right? The members of Congress who voted for the tax cut bill in 2017 were very clear. They did not want to kill the ACA. They told us this. They said it on the record. They said it in the press. We know what they thought, right? So if the only question is what did Congress think in 2017, I'm with Mike on this one, right? But I think the answer is more complicated. We're not dealing with one Congress. We're dealing with two Congresses, right? We have Congress in 2010 and Congress in 2017. The Congress in 2017 basically said we just want to kill the penalty. The Congress in 2010 said something else. They said we want to enact this mandate, and the mandate was essential to the operation of the law. They put the word essential in their findings. This was not a severability clause, but the Obama administration treated these findings as if they were a severability clause in the Obamacare litigation. So we have Congress in 2010 saying one thing and 2017 saying another. So maybe we say, look, Josh, hindsight's 2020. By the time we get to 2017, we realize you don't really need the mandate. It's not really important, and it wasn't. But I'm going to give you something that will blow your minds, right? Ready for this? In 2017, the ACA was unconstitutional. Congress then took an action which arguably made it unconstitutional. Maybe the remedy is the 2017 Congress screwed up. Maybe the remedy is you put the tax back in place, right? There's an old case called Frost versus Oklahoma Commission, which says that if a later Congress renders an earlier statute unconstitutional, the remedy is to strike down the action of the later Congress. Maybe the remedy is you put the tax back in place and Obamacare is constitutional again. There's no doubt about it, right? In other words, we treat what the 2017 Congress did as a nullity. We just pretend they didn't do it. But if that's right, what they do is a nullity, then their intent becomes less important. I think you cannot discount the intent of Congress in 2010. They made a statutory finding which has not been repealed, and I think the court has to give credit to that. But I'm going to concede. This, I think, is a question that the doctrine doesn't look too good for the plaintiffs, but I think there is some argument to the contrary. Now let me pivot one more step. Justice Thomas, right? Justice Thomas always has a different way of looking at basically everything. And he had an opinion a couple years ago in a case called Murphy versus NCAA. This was a case about sports gambling. And Justice Thomas basically does what he always does. He says, everything we know about severability doctrine is wrong, right? Why? Generally, if I go to court and I challenge a provision, I can only challenge those provisions that injure me. I can't just say, okay, I hate all these other laws, but I'm going to challenge only one provision. Severability is an exception to that, right? We had a case called Holman's Health versus Hellerstedt a couple of years ago. This was an abortion case from my state of Texas. The law had these restrictions. For example, doctors had to have admitting privileges to hospitals, and clinics had to meet these surgical standards, right? But there were other provisions of the law that were pretty innocuous. So for example, part of the law said you have to have smoke detectors. Okay, does having a smoke detector requirement impose an undue burden on abortion? I don't think so, right? You can put a $10 smoke detector up in the wall. But the court declared the entire text of abortion law unconstitutional. On what grounds? Severability. They said we cannot pick and choose. The entire law has to go. Thomas says that's the wrong approach. We should be more specific. We should ask, does a provision injure the plaintiff? Okay, then we can enjoin it. Otherwise, you have to leave it in place. I think that's what's going to happen in the Obamacare case. I don't think setting aside the entire law is the correct remedy, whoever's right about intent. I think the remedy has to be which provisions actually injure the plaintiffs. Now, that doesn't mean complete a declaration of unconstitutionality. It means partial, which is why I think in the Fifth Circuit we'll get a remand. We'll get a remand to the district court to decide what actually injures the plaintiffs. I don't know what the answer to that question is, but I don't think we get a full affirmance in that front. But let me I'll close in this note. Severability doctrine's murky. I don't know where the court's going to go with this one. But if the court does nothing else, they simply say, yes, they're standing, and the mandate cannot be saved anymore, I'm okay with that. I'm not here to kill Obamacare. That's not my interest. My interest in the commerce, necessary, and proper clauses. Texas disagrees, right? I think they want to kill Obamacare, which is their prerogative to follow this lawsuit. But I tried as best as I can to disentangle these sort of political arguments from the legal questions. I think I'm right on time. Thank you all so much. I turn it with my friend Mike, and we'll have a good discussion. Thank you.
So first I want to thank Josh for making the trip to Ithaca, which is, as you know, centrally isolated and so not easy to get to. It's really great that you came out here. We're very grateful. And second of all, thank Fellow Society for sponsoring this event. I put on my blog today something that turns out to be sort of not true now, but I'll say what I say. So FedSoc likes to bill its events as debates because debates draw audiences. I've had this discussion with FedSoc over the years, and so I've debated many guests, and because a lot of Federalist Society speakers tend to be libertarians, and I'm a liberal, and there's a lot of overlap between liberals and libertarians, a lot of these debates end up being mostly agreements. But I put in the blog that I thought Josh and I would disagree today, and so it really would be a debate. And I'll find some points of disagreement, but I think it'll be more of a discussion anyway. So I'm going to give you my argument for why I think the right outcome in the Fifth Circuit is that the plaintiffs should lose the case. But not all of that is sort of strictly speaking a debate. And I'm not predicting that they will lose the case. I don't really, I mean, based on the oral argument, if I had to lean, I'd say that the plaintiffs will win at least in part. So there's that. But so here's why I think they ought to lose the case. And I want to focus on 2 points, and there are 2 of the points that Josh did also, but they sort of overlap. So I think standing and the merits overlap, so I want to treat those together. And then I'll turn to severability. And the reason I say that standing overlaps with the merits is because both with respect to the question of whether there's an injury and with respect to the question of whether the law now falls within the affirmative power of Congress, the real question is, does the law require anything right now, right? The position of the House of Representatives, which has intervened to defend the lawsuit because the administration is at this point not really defending it, right? Their position is there is no mandate. First of all, there's no language in the statute that's called a mandate. What's called the mandate by the colloquially is Section 5000A, which is a sort of which is called a shared responsibility payment. The idea is that you pay some amount of money for the health insurance you purchase on an exchange if you're not covered by Medicare, Medicaid, the VA system, employer-based health insurance, and you fall within the income range that requires you to have insurance. Most of the people in that range get a subsidy, some don't. Okay, so that's what it is, and that's what's conventionally called a mandate because it does have what sounds like mandatory language. But if that mandatory language, right, shall purchase health insurance, turns out to be illusory, right? If it turns out that it doesn't really require you to do anything, then that defeats the plaintiffs both on standing, because they're not injured by failure to comply, and on the merits, because Congress doesn't need affirmative power to tell people you don't have to do something, right? And so I want to focus on that question. I'm going to do so by telling you a story. You're supposed to perk up the stories. All right. So, as some of you know, I'm a vegan. I'm a vegan primarily for ethical reasons, but I also care about my health. In general, eating a vegan diet, as long as you're not subsisting on, Coca-Cola and potato chips, is pretty healthy. But there is one way in which vegans, if they're not careful, have a health risk, and that is vitamin B12. So vitamin B12, those of you who are eating dead animals are obtaining through the animal flesh, because the animals eat the grass, right? So let's say you're eating a beef burrito, right? So the cow that you are now eating, right, ate a bunch of grass. The grass was growing out of the ground. In the ground, there was the soil in which bacteria live. Those bacteria create vitamin B12. It is in theory possible to get vitamin B12 by eating vegetables, but only if you don't wash them, right? And because most people in modern societies, including me, don't like to eat a lot of dirt with our vegetables, vegans are recommended to take a B12 supplement, okay? But they're not just recommended. This is a language I got from a government website. It's a government website called health.gov, sponsored by the federal government, pursuant to an act of Congress, 42 U.S.C. section 300 U-10, right? Here's what it said. Vegans eat only food of plant origin. Because animal products are the only food sources of vitamin B12, vegans must supplement their diets with a source of this vitamin. Sounds like a mandate. I must supplement my diet with vitamin B12. Oh, if I just read that, I would think, gee, I better go to the store now. I actually don't, suppose I'm a vegan who doesn't care about his health. Maybe I'm trying to commit suicide by vitamin B12 deficiency, right? I read this, if I'm a law-abiding citizen, according to Josh's argument, right, I'm now mandated to take the B12. That's horrible. That is the reductio ad absurdum that the plaintiffs brought in the first Obamacare case, right? They said a mandate to purchase health insurance is like a mandate to purchase broccoli, which is like a mandate to eat broccoli, which is like the government shoving broccoli down your throat. And even, we pinkos thought, well, government can't shove broccoli down somebody's throat. That's a violation of the right to bodily integrity. Likewise, although I might voluntarily take a vitamin B12 pill, if the government attempts to force me to eat it, that's a violation of substantive due process, right? And so the government can't do that. What should we do in response? I think the answer is obvious. We read that language, must supplement their diets with a source of this vitamin, to mean if they want to be healthy, right? There's a condition there. Yeah, you must do that unless you want to get sick from vitamin B12 deficiency. Basic common sense construction. Now let's turn to the shared responsibility payment, or the so-called mandate in Obamacare. It's true, before the 2017 amendment, the way to read that was, the most natural reading was, you must do it. And the reason why you have standing to make the complaint is because if you don't do it, you would have to suffer a penalty. Whether we call that penalty or a tax or whatever it is. But after 2017, the most natural way to read it is the same way I read the vitamin B12 argument, right? It's not language, right? You must do it, or else, or else what? Or else nothing, or else pay $0, right? So it's a basic principle of constitutional interpretation that as between a construction of a statute that's going to render it unconstitutional and one that's going to render it constitutional, you choose the latter. So if the choice is between you have to do this or else you are branded a lawbreaker, or you have to do this or nothing, you choose the latter, given that, I agree with Josh, there isn't the authority in light of the fact that 5 justices thought there wasn't authority under the Commerce Clause in an FAB against Sebelius, there isn't the authority to command people to do this. Now, more broadly, we might ask the sort of philosophical question, if the government mandates something but imposes no penalty, has it actually mandated it, right? It's kind of like whether, a tree falling in the forest with nobody there makes a sound. The answer to that is, of course, it makes a sound. But the answer to this question is less clear. There's a sort of philosophical question about whether the law imposes moral obligations, etc. But we can put all of that aside and say, yeah, that's ambiguous, but the basic principle of constitutional avoidance says we don't need to get into any of that, because as between a construction that says you gotta do it and therefore this entire regulation of this multi-billion industry collapses, and one that says, oh, it's just now recommended, which is, by the way, how virtually everybody spoke about what they were doing in 2017, you choose the latter. Okay. Second point, severability. I agree with Josh that the question with respect to severability should not simply be what is the sort of secondary intent of Congress, right? Severability means, right, here's an invalid portion of the law. Would the legislature have wanted the rest of the law to survive, to be severed from that law, versus would the whole thing have to go with it, right? But it's not only about what they would have wanted. It's also fundamentally about whether the rest of the law can function independent of the severed provision. I also agree with Josh that the Congress that enacted the original ACA in 2010 thought that it was pretty necessary to make the whole thing work, right? Exactly because of the point he identifies, the free rider problem, right? One of the central features of the ACA is this prohibition on insurers denying insurance because of pre-existing medical conditions. But if you are a relatively healthy person and you know that an insurance company can't deny you coverage because of a pre-existing condition, you might choose not to buy health insurance, wait until you get sick, and at that point you buy your health insurance because now you're covered for your pre-existing condition. And so the mandate was a way around that. And Congress thought it was essential. But you know what? It turns out it isn't. Why? Well, a couple of reasons. One is that actually the subsidies for most of the people who are purchasing health insurance make it a good deal. The second is that the market has just sort of evolved. So there was a big story yesterday. Alex Azar, who is, basically the government official in charge of the whole system, said, hey, premiums are going down and the number of insurers is going up. It wasn't supposed to happen without the mandate, but it has, right? The system is pretty robust. It survived the Trump administration's and Congress's efforts to kill it. And so the 2010 Congress was wrong in thinking that the Affordable Care Act couldn't survive without the mandate. And that is, in some sense, the most important question, because on grounds that conservatives should care about, textualist grounds, you don't really want severability to turn on what Congress's hypothetical intent would have been. You want it to turn on the sort of objective factors, and here the objective factor is, does the thing work without the invalid provision? And so my view is that even if you reject my argument that the mandate is no longer a mandate, and you say it is a mandate but it's unconstitutional, so you strike down the obligation to buy health insurance, but you leave the rest of the law intact. Beyond that, I certainly agree with what was initially the Trump administration's position, but they subsequently backed off on, which is that even if you think certain provisions are closely interrelated to the mandate, there are many that have nothing to do with it, right? Like as Josh says, like the smoke detector provision. So here's one. You can stay on your parents' health insurance until the age of 26, right? The Affordable Care Act provides for that. Nothing about the mandate has anything to do with that, but under the district court's decision, you strike down the mandate because the tax is $0, and now kids get kicked off their parents' health insurance at an earlier age, right? There are all sorts of provisions like that, requiring evidence-based medicine, et cetera. And so it seems to me wildly far-fetched to say that this entire edifice, right, the provision in Whole Woman's Health, yes, there were additional provisions, but the Affordable Care Act has, hundreds of provisions that affect billions of dollars of the economy, and the idea that you would throw all of that into chaos because of this tendentious decision to read the provision that says you don't have to pay any penalty to mean, well, you still have the mandate, seems to me far-fetched. Finally, let me just say that the politics of this are completely unclear. For one thing, a rule of non-severability, right, a general rule of non-severability, is going to be good for whoever wants to challenge laws. And it depends on whether the law is something you like or you dislike. Right? So there's no obvious ideological valence to that. And that's why you saw Justice Thomas on one side of it in one case and on another side of it in the other case. It's not even clear what the short-term politics are. If I were running Elizabeth Warren's campaign, I would be hoping that the Fifth Circuit strikes down the whole law and that the Supreme Court quickly affirms that. Because nothing is going to generate support for Medicare for all more quickly than a determination that the existing system is illegal. And so, I think this is or ought to be a case of be careful what you wish for.
Thank you so much. I didn't know to bring props, so I appreciate that you had the vitamins with you.
You want one?
No, I think I had some. I had some meat this morning. I'm sorry. Sorry. It was fish. I guess it's not quite as bad, but I did have some salmon. So smoked. I don't know. Does that give me B12?
I don't know whether you get B12 from fish.
We'll have to adjust for lunch.
Mercury.
There were some eggs on it as well, so I'll okay. Mike and I think, do agree on a lot. I think it's a general matter when the government says you shall do something. You can read that as non-mandatory. But we have an opinion from the court where the court said this was an unprecedented purchase mandate that said you have to maintain insurance. I think the lower courts are bound by that finding. Constitutional avoidance is always an option, and I don't ever pretend to know how the Chief Justice comes out. But my argument is a matter of NFIB, the shall issues are been decided. And if the shall issue is decided, the standing issue is decided as well. Standing and the merits are closely bound up together. If you have one, you have the other. If you don't have one, you have the other. So if you lose on standing, you lose in the merits. If you win in the merits, I think you have standing. So you get either all or nothing. In terms of severability, I don't know which way this cuts. I think the issue, the interplay between the Congress in 2010 and the one in 2017 is complicated. And I don't think our current doctrine considers two Congresses and how do you balance their intents. I do think the issue is complicated. Maybe Justice Thomas's approach and Murphy gets a few more votes. It's possible. And if that happens, then severability doctrines, it changes. I'll give you just another analogy. Overbreath doctrine in the First Amendment, right? I can challenge a speech restriction even if my own speech can be prohibited because of this overbreath doctrine. That always bothered me from an Article 3 perspective Maybe that's now in jeopardy if the court moves this other direction and ties severability to Article 3 standing. I don't know where it goes. Last point, the politics. I don't know which way this cuts either. Elizabeth Warren's not calling me, I'm sure of that, but there's Donald Trump for that matter. But this is a tough issue. And let me give you a couple of points on timing. We are now October 23rd. Generally, for the court to decide a case, they have to argue it in the last week in March, and they'll get a decision by June. To get on the docket for argument in the last week of March, generally you need a cert grant by the beginning of January. Mike, is that about right? End of December, beginning of January. It fluctuates, but if you get cert granted by the end of December, beginning of January, plus or minus a week. In order to get a cert grant decided that quickly, unless you expedite, you would need a cert petition in about 2 or 3 weeks. Mid-November, early November, because that gives the other side a chance to reply. It goes up for conference at the end of December. If the Fifth Circuit rules in the next 2 or 3 weeks or so, I think the case can go up this term. They may not. This is not a preliminary injunction. There's no urgency in the traditional sense. Maybe the judges in the Fifth Circuit say, let's rush this to the court. Or maybe they say, let's just take our time. But even if the Fifth Circuit rules in the next 2 or 3 weeks, I don't think you get an affirmance with an injunction. I think you get a partial affirmance with a remand to decide what provisions are actually injuring the plaintiffs. And the Supreme Court may say, why are we taking this case now? It's preliminary, right? There's no injunction in place. There's also the possibility that the liberal justices want this up now, right? What do you think? If you're Elena Kagan or Ruth Bader Ginsburg, do you want this decided in June of 2020, before the election, or June of 2021, after the election? And again, whether Trump wins or loses, this case remains, right? DOJ can flip their position, but the case continues, right? When do you want John Roberts having this crucible in his hand, before or after the election? Which is why I think this will be one hell of a term this upcoming June. We'll have an impeachment trial, we'll have Obamacare, we'll have abortion, we'll have emoluments, just everything will just dump in the court at the exact same time. So this will be a very, very busy June. Thank you.
And yeah, I want to open it up also for questions. If anyone has any questions that they want to ask either professor, please feel free.
Don't be shy. Well, can I say one more thing?
Please,
Absolutely.
please.
So just on one, so I agree about the timing. One point about whether NFIB against civilians controls the shall question. So I guess the place I differ is, right, it's true they don't amend anything other than the text, but the shall question is decided in light of there being a non-zero tax, right? I think it's now, that's not precedent for, or it's weakened precedent for what shall means when the penalty is, when the tax is zero. So I do think that if if the Fifth Circuit were to say we distinguish NFIB because shall means something else now under the shadow of a different kind of constitutional avoidance, I think that would not be defiance of Supreme Court precedent.
No, I think they can make that distinction. NFIB was not about the penalty, it was about the mandate by itself without a penalty coming into effect later. It was all about what is a current injury. So I've always read, this is inside baseball, but in 2012 there was a huge debate in the oral argument on this exact question. This was argued about for almost 20 minutes between Chief Justice Roberts, Justice Kagan, and Greg Katsas. Greg Katsas is now in the DC Circuit. He was the lawyer for NFIB, and they argued about the exact question. The NFIB plaintiffs were very clear. They were not challenging the penalty. This was all about the mandate by itself, regardless of the consequences. So in my mind, this issue is litigated to death. It was already resolved because I've understood it for almost 8 years through this fashion. You could always distinguish it away, but that's how I've always understood this litigation to proceed.
And I guess I want to say, but all of that was shadowed by the possibility of reading it under the taxing power, which I agree is sort of off the table now. And by this additional, this wasn't Katsas' argument, this was Vicki Jackson's argument.
Yeah.
But there was this other question, which is even insider baseball, insiderer baseball, which was whether the case could even be decided in its existing posture, because there's something called the Anti-Injunction Act that says that if you're going to challenge a tax, you have to pay the tax, and then sue for a refund. And everybody thought that was a terrible idea because it would put off the adjudication of the constitutionality until after the whole system was up and running.
Yeah, no, I agree. The Tax Anti-Injunction Act was actually extremely important. The court appointed an amicus, Professor Jackson at Harvard, to make this argument. No one paid attention to it except for your Professor Lawrence Tribe. He was.
So Neil Siegel and I wrote a piece in the Yale Law Journal on this.
Can I give Tribe some credit? So the day or two after the arguments, Tribe was teaching a class where he said, pay attention to this argument on the taxing power. We almost got the argument verbatim that Roberts, but I'm sure you and Siegel did, so I apologize if I missed it. I was trying to give some credit. I was trying to give Tribe some credit. You know, we have to give it where it's due. Okay.
All right, well, if there are no questions.
There are no questions?
Surely somebody must have a
It's
question.
just nothing?
Outraged comments?
Did nothing we say talk about? You know, Mike, I did debate on UT with this with Steve Vladeck. There were no questions either. I think people don't care about this topic. I'm serious. I think there's just burnout in Obamacare. There's just so much insanity on a daily basis with Ukraine and Russia and subpoenas and whistleblowers. Like, who the hell cares about healthcare? Jeez.
Could be it.
Well, if there
Are you worried about being kicked off your parents' insurance?
That could be the case, right? But anyways, well, thank you to our wonderful speakers, and
Wow.
I appreciate you all making it out here at lunch, and I hope you got your food and enjoyed, and we'll see you next time. Hope you all had a great fall break.
Thank you. Mike, no questions. I've never had that before. That's